Hi, I'm Renee Osipov with Chelle Law, and we assist veterinarians with employment contract issues. Today, I'm talking about non-solicitation clauses versus non-compete clauses. How are they different and how are they the same? So I'm going to start with the non-solicitation clause. They're normally located in the section of your employment agreement. Normally it's stated under restrictive covenants. So a non-solicitation clause is just a promise to not solicit directly and sometimes indirectly clients, employees, and sometimes third-party contractors. So let's talk about this. A non-solicitation clause is normally broke down into a couple different parts. So the first part is going to have the restricted period of time. So this is normally while you're employed and then after your contract terminates. Normally it's anywhere from 1 year to 3 years. It really should be only 1 year, but it's for a period of time that you cannot, like I said, solicit those group of people. So the second part is going to be what groups of people can you not solicit. So first it's going to be clients. And then next is probably going to be employees. And then sometimes we see third-party contractors. And this can be, marketing, supplies, anything, any type of contract that your, then employer had enforceable at the time. So we have the time, who you cannot solicit, and then let's talk about solicitation itself. So it's saying you're promising that you're not going to solicit. Most of the time it says directly or indirectly. Indirectly should really be defined in the contract what that means. Solicit to me really means reaching out directly to those groups of people. We can use clients for an example. Reaching out directly to them, enticing them, encouraging them to leave and come with you. That's when you're definitely going to be in violation of a non-solicitation clause. Also, just want to address general advertising is normally talked about in the clauses, and it's normally not considered direct or indirect solicitation. So this is when you're advertising to the masses. It might be billboards, social media, commercials. Those are examples of just general advertising. When you start targeting those specific groups of people that we just talked about, like referral list or information that you're taking from the company, that may be considered soliciting. So you want to be careful, read your employment agreement very carefully to know. So that's a non-solicitation. So next we can move on to a non-compete clause. So what is a non-compete? So it's also going to be located in the restrictive covenants, and a non-compete clause is just a promise to not compete with your former employer. So it's broken down in a couple different parts too. So it first starts with a period of time that you're restricted from competing. So this is going to be during your employment, and then normally anywhere from 1 to 3 years. Again, always, in my opinion, should be limited to 1 year that you cannot compete. And then you're going to look at what's actually prohibited. So normally it would be the same type of services that you were providing with your then employer. That's what's restricted. Sometimes it says any practice of veterinary medicine. They can be very broad, so you want to make sure that you read it very carefully. And then the last part of it's going to be what area is restricted. So most non-competes in most states are going to say a mile radius, and it will say anywhere from 5 to 10 miles from a certain location. It might be your primary location, it might be any location that you're providing services for, or any location that the practice currently owns. So you want to be careful to know what that radius, where is it attaching, one location or multiple locations. It also depends on where you are in the United States. If you're in New York City, it might not actually be miles, it might be city blocks. But if you're in a rural area, it might be more miles. And if you're in a small city, it might be considered in miles. So it kind of just depends. But again, it's going to have a restricted period of time. You're going to know what you're actually restricted from doing and then what area you cannot compete in. So non-competes and non-solicitations are similar in the fact that they're both considered restrictive covenants, which is a promise not to do something. They normally kick in after your employment has ended, and they're normally for about the same period of time. This is to help the employer's interest if they have, trained you or you're giving special services, that you're not going to interfere with them. They're both enforced normally the same way. So the first way is called equitable relief, which just means that your former employer, if they think you're in violation, they can bring an action before a judge and they would sign a temporary restraining order or an injunction saying that you couldn't solicit those patients or work in that restricted area. And then some contracts also have liquidated damages. So they're saying if you are in violation of those clauses, you may have to pay the company a specific amount of dollars that they're anticipating would be considered their losses. A couple more things about non-competes. You do want to be careful and check your state law. Some states do not enforce non-competes, so you want to double check that. And some of them, there's a new trend now, depending on how much you make annually. So if you make below that threshold amount, non-compete is unenforceable. So if you'd like more information on non-solicitation clauses or non-compete clauses, you can check out our website, Chelle Law, CHELLE law.com. And we have lots more information and content on there, and we're always happy to set up a consultation with one of our attorneys. Thanks.